Good morning. I'm sorry about the slight delay this morning. There's some difficulties with the broadcasting system, but these are now resolved. Good morning, Mr. McGowan. Would you take the oath, please? I swear by Almighty God
I swear by Almighty God
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Miss Thompson.
Good morning.
Good morning.
You are Stephen McGowan.
That's correct.
How old are you, Mr.
I'm
McGowan?
50.
And you are the Deputy Crown Agent for Litigation
That's correct.
within the Crown Office and Procurator Fiscal Service, and you have been since April of last year.
I am. Yes.
Before we begin, can I ask you to open up the blue folder that's in front of you and take a look at what's inside? There should be there a copy of the Rule 8 request that the inquiry sent to you. That's SBPI 00440, dated the 11th of December of 2023.
I have that, yes.
You have that. Grand, and there should also be a copy of your response to that request, which we will bring up on the screen, please. It's SBPI 00431.
I have that, yes.
We'll bring it up and just have a brief look at it. So this is your response to that request. It's 298 paragraphs long, and if we scroll to the very, very bottom, please. We'll see that you signed it on the 12th of January of this year. Your signature has been redacted on the screen, but hopefully is visible on the copy in front of you. So this is a procedure that we refer to as Rule 8 procedure, whereby the inquiry can approach a witness and ask them to give a written statement. The Rule 8 request set out the matters that the inquiry was asking you to cover in your statement, and your response is, as the name suggests, your response to that request and your answers to those questions. Also in the folder before you are a number of notebooks that you kept during the time that we're concerned with in this inquiry. I don't intend to take you to those notebooks, but they're there in case you would find it helpful as an aide-memoire to refer back to your notebooks. I want to begin by asking you a little bit about your qualifications and experience, and I see from your statement that you qualified as a solicitor in 1997.
That's right, yes.
And you've been with COPFS since 1999.
I have.
You explain at paragraph 4 of your statement, if we could perhaps scroll up to that. I'll read it short, but you explain there that in 2012 you were the Deputy Director of Serious Casework, and you were tasked with setting up 2 new departments, the SFIU, Scottish Fatalities Investigation Unit, and what we've been calling CAPD, the Complaints Against the Police Division. So you set up those 2 divisions or units in 2012.
Yes.
And for a period of 2 years thereafter, you had oversight of those 2 units, but you explain in paragraph 5, if we scroll down, and again I'll read it short, you explain there that the post of Deputy Director for Serious Casework was split in 2014, and the responsibilities of that role were shared between 2 new posts, Procurator Fiscal for Major Crime and Fatalities Investigation, and Procurator Fiscal for Organised Crime and Counter-Terrorism.
That's correct.
And you explained too that you became the Procurator Fiscal for Major Crime and Fatalities Investigation, and as such you retained responsibility for SFIU, and the head of SFIU back then I think was David Green.
That's right, yes.
However, responsibility for CAPD fell to the PF for Organised Crime and Counter-Terrorism, who was, I believe, Lindsay Miller.
Yes.
And that unit, we've heard, was headed up by Les Brown at the time.
That's correct, yes.
So at the time of the death of Sheikh Bayo in May of 2015, you had responsibility for SFIU, but not CAPD.
That's correct, yes.
You explain paragraph 6 of your statement, and again I'll read this short, that in May of 2016, following further restructuring, you became the Procurator Fiscal for the High Court, and from that point onwards, you no longer had responsibility for SFIU.
Yes, that's correct.
That said, you explain in paragraph 33 of your statement that you were involved in this investigation in the very early stages, When the investigation was allocated to CAPD, you remained involved as you put it, a sounding board, and you gave advice and guidance.
Yes.
And that continued until 2018.
That's right, yes.
Can we look, please, at paragraph 61 of your statement? Here you explain that during the early part of the Perk investigation, you were involved in assisting and providing guidance to David Green and then to Les Brown in the direction of the Perk investigation, and you did so due to your recent experience in dealing with CAP cases and deaths, and you did so to the best of your ability. So you had recent experience of dealing with CAP cases and deaths. Had you experience of dealing with deaths in custody?
There were deaths in custody as part of that role through SFIU, yes.
Had you experience of dealing with a death in custody following restraint?
No, I don't think so.
And had you experience of dealing with a death in custody where race was a factor for consideration? So you explain in this paragraph that you gave guidance and direction to David Green and then to Les Brown on the direction of the Perk investigation. You say elsewhere that you did continue in this advisory capacity until 2018, by which point the Perk had reported to the Crown. So should we understand that you also gave advice and guidance in relation to the Crown's own investigation?
Yes, until about that point in 2018, when I moved role, and by that time the investigation was well underway and dedicated Crown Counsel were involved, and so the need for my guidance was no longer there, and by that time the relationships with Perk, which was part of the reason why I was involved, because I had been involved with them before, were we had learned and we had moved on, and those relationships were made with the rest of the team and the rest of those who had responsibility for the case.
Do you recall when in 2018 you moved away from the inquiry?
I think over the course of late 2017, my role gradually became less because Crown Counsel had become involved. I think when I took up the new post was somewhere around and about the early summer, so perhaps June. But I can't be absolutely definite about that. If it's important, I could find out.
No, I dare say it's not. And which new post is that you're referring to?
I then went to become the Deputy Crown Agent for Local Court at that point.
Okay.
So I was involved with all the Sheriff Court cases and no longer involved with this kind of work at that point.
All right. So you became the PF for the High Court in May of 2016.
Yes.
And then at some point in 2018, the DCA for Local Court.
That's correct, yes.
And you've explained that your advisory role was effectively phased out as dedicated Crown Counsel was brought in.
Yes.
I'd like to ask you some questions about the initial letter of instruction to the Perk. And I wonder if we can bring up on the screen COPFS 02539. And this is a letter which you sent on the 5th of May to Irene Scullion, Head of Investigations at the Perk.
Yes.
And if we look at this briefly, please, it relates to the death of Mr. Bayo. And you state that in terms of Section 33A of the Police, Public Order and Criminal Justice Scotland Act 2006, I write to formally confirm the request made on the 3rd of May 2015, and we've heard that was a request made over the telephone by Mr. Green, and it was a bank holiday weekend, that you carry out an investigation in relation to the circumstances surrounding the death of Mr. Bayo, and there were two areas which required investigation, and they were the circumstances leading up to the incident, namely Mr. Bayo's movements late on Saturday the 2nd of May and during the early hours of Sunday the 3rd of May prior to contact with the police, and the incident in which the police became involved with Mr. Bayo shortly after 7 o'clock on the morning of the 3rd of May. If we skip a couple of paragraphs, the paragraph at the bottom of the screen reads, my colleague Les Brown, Head of CAPD, will be the Senior Fiscal with oversight of this case and will bring in such assistance from COPFS as required. And if we scroll to the bottom, please, we see that this letter was signed by you. So that letter was sent out on the 5th of May. And I understand that there is an earlier version of that letter,
Yes.
and I believe that you were shown a copy of it, and you comment on it in your statement. One of the differences between the two versions of the letters is that the earlier version refers to David Green, head of SFIU, having oversight of the investigation.
Yes.
Now, I don't think we need to bring up the earlier version of the letter, but it was signed by you.
Yes, it was.
To your knowledge, was it sent to PERC, that earlier letter, or was it stopped?
I can't recall. I suspect it may have been stopped because I don't refer to this being a subsequent letter in the letter. I may have, if it had been sent, I think I would have made reference to that and said that this superseded the earlier letter.
I see. So can we take it from the difference between these two letters that at some point on the 5th of May, a decision was taken that the investigation should sit within CAPD rather than
Yes.
SFIU?
Yes.
Now, who made that decision?
I don't specifically recall any discussion about it. There must have been a discussion about it. I imagine that would have involved myself, John Logan, Lindsay Miller, but I don't recall the specific discussion.
And who would have authority to make a decision of that sort, that a case of this complexity and profile should sit within one unit rather than another?
Either of us could have made that decision. CAPD sat within Lindsay Miller's remit, so she would have had to be involved in that. Mr. Logue oversaw both of us, but any of us would really have had the technical authority. But there must have been a discussion as reflected between the two drafts of the letter. I don't recall it.
You don't recall it. Now, if you don't recall, you might not be able to help me with my next question, but I wonder whether you have any recollection as to why the view was taken that the investigation should sit within CAPD rather than SFIU.
Again, I don't have a specific recollection of that, but I would say that it wasn't of any great significance. We always knew that this was going to require a bespoke approach, so we would have a specific team would deal with a case of this nature, and that case would be built around a particular unit. My recollection at the time from my management of SFIU was that there was a lot going on in SFIU at the time. It was a new unit. It inherited a lot of cases. There were some really big cases within SFIU and also in the Health and Safety Division that David Green was also responsible for. There were a number of helicopter accidents. There was the bin lorry incident as well. There was also the work that was going on with the Scottish Government, which was the precursor to the new Fatal Accidents Act, which came into force in 2016. That bill was through its passage of Parliament at that time. So it seemed, I think, that it was more convenient to put it in CAPD, was my recollection of the surrounding circumstances. But as I say, I could be wrong about that, and I don't have any recollection of a specific conversation that said that.
And would it have made any difference if the case had stayed within SFIU?
I don't think so, because it was always going, in my mind, to be a bespoke response. So there was always going to be additional people coming in. Either unit couldn't have dealt with a case like this on its own. You would always have had to put additional people in, but it seemed, because of what was going on in SFIU at the time, that it would have been easier to accommodate in CAPD.
Can we scroll back up to the top of the letter, please? In the first paragraph, you explain that the instruction is in terms of Section 33A of the 2006 Act. And we have heard evidence that there is a subsection B, which in turn divides into Roman numeral 1 and Roman numeral
Yes.
2. And reading them short, Roman numeral 1 refers to investigations where there's an indication of criminality, and Roman numeral 2 would encompass an investigation into death in
Yes.
custody. This letter doesn't specify which subparagraph
Yes.
The investigation was instructed by reference to, and you explain at paragraph 76 of your inquiry statement. We don't need that on the screen, but the hard copy is before you, that you didn't state which subparagraph was applicable. And this was a deliberate
Yes.
thing on your part. You say that at the time the letter was sent, it was unclear what was happened, and so it was deliberate. It was intentional
Yes.
that you weren't more specific. Can you expand, please, on your thinking in terms of the decision not to commit the inquiry to being under subparagraph B1 or B2?
Yes, so I didn't think that we had enough information at that time to be clear what had happened. I think when I was drafting the letter, I took the view that it didn't matter whether I specified at that stage whether it was a crime or whether it was a death investigation, in that the purpose of the letter was to make it clear that this was a Crown-directed investigation as opposed to one of the other types of investigation that PERC may become involved in, to make that plain to everyone involved, and to formally give PERC the instructions that they had. I didn't think that there was sufficient information to say that a crime had been committed, although that's entirely possible because it was apparent from the information that we had that there was evidence that violence may have been used, and a question that may arise and subsequently did arise would be whether or not that was justified.
I want to move on to ask you some questions about the European Convention and Articles 2 and 14 in particular. And we've heard quite a lot of evidence about the requirement of these articles already. And a number of witnesses have been taken to a quotation from one of the cases, Da Silva, which I'll read to you. The court has in its case law established a number of requirements for an investigation into the use of lethal force by state agents to be effective. In summary, those responsible for carrying out the investigation must be independent from those implicated in the events. The investigation must be adequate. Its conclusions must be based on thorough, objective, and impartial analysis of all relevant elements. It must be sufficiently accessible to the victim's family and open to public scrutiny, and it must be carried out promptly and with reasonable expedition. Is that passage familiar?
Yes, it's familiar to
you?
me, yes.
Now, a number of witnesses have been taken to quotations from the case law and the principles that can perhaps be drawn from the case law, and they have agreed that for an investigation into a death to be Article 2 compliant, it requires to be effective. You would agree?
Yes, I would agree with
Sorry,
that, yes.
I see you nodding,
I will,
but
yes,
the proceedings are being transcribed. And to be effective, an investigation must be adequate.
Yes.
And where a death follows the use of force by state agents, an adequate investigation must be capable of leading to a determination of whether the force used was or was not justified.
Yes.
And the standard to be applied is that of no more than absolutely necessary. Again, you agree?
Yes, I agree with that. Yes.
And further, when a death is at the hand of state agents, taking Article 14 in conjunction with Article 2, authorities have an additional duty to take all reasonable steps to unmask any racist motive and to establish whether or not ethnic hatred or prejudice may have played a role in events.
I agree, yes.
And they should pursue that investigation with vigour.
I agree.
So these are positive obligations that would have fallen to both the PERC and Crown Office in terms of Articles 2 and 14.
I agree, yes.
To be discharged both through the PERC investigation and also through the Crown investigation.
Yes, they would.
And central to the Crown investigation, of course, is the recognition process.
Yes.
I'd like to begin by asking you some questions about the PERC investigation,
Yes.
and then we'll look at the Crown
Okay.
in a little while. And I wonder if we can bring up on the screen paragraph 63 of your statement. So this is a response to question 27, and to save us flitting between documents, I'll simply read out
Okay.
question 27 for you. Question 27 was, in your view, was race sufficiently covered in COPFS instructions to PERC? Did COPFS provide sufficient guidance and advice to PERC in order for them to investigate the issue of race sufficiently? So let's look at your answer. Your response was, in my view, everyone was aware that race was a matter at the heart of this investigation. From the first telephone call I had with David Green, the question of the deceased's race and whether it was a factor was discussed. No one was in any doubt that it was an issue. Whilst no specific instructions were given to consider race as a motive, my recollection was that it was clearly discussed at the time, and everyone involved was seized of the requirement to investigate the potential for race to have been a motive. I would like to also now, before we move on and I ask you questions, look at paragraph 169, which expands on this theme. This is a response to question 95, and again, I'll simply read question 95 out. Question 95 was, what is your recollection of how race was investigated by PERC and COPFS? How did this change or develop over the course of the investigation? Were you satisfied that race was fully explored in the investigation? So that's the context for what you say in paragraph 169. Again, let's look at it in full. The question of race, or more particularly, whether there was any racial motivation behind these events, was a factor from the very start. From the first telephone conversation I had with Mr. Green, it was apparent that questions of racial motivation would require to be investigated. In the years since the reports following the murder of Chokar, these were matters that were considered routinely and in every case. One of the reasons that the case was considered to be so high profile and sensitive was because of Mr. Bayo's race. At an early stage, specific allegations of racist conduct on the part of specific officers were brought to our attention. That caused Mr. Brown to write to PERC to give specific instructions on that matter. But even before then, no one was under any doubt that this was something that required to be investigated. On reflection and looking at the documents provided to me, it's unfortunate this was not more explicitly documented. Separate allegations were made of more general racist conduct in the former Fife Constabulary and Fife Division. These were separately investigated and reported to Cap D. I was satisfied that questions of race were being explored appropriately. So I'd like to ask you some questions arising from my reading of these two paragraphs. You say that whether there was any racial motivation behind these events was a factor from the very start. So I just want to be absolutely clear that what you're referring to here is the question of whether race was a motivating factor in the actions of the officers who attended Hayfield Road. I mean to that. Yes, thank you. And you say that from the first conversation with Mr. Green, and I understand he called you on the morning of the 3rd of May. At 9:30. At 9:30 in the morning. So from 9:30 on the morning of the 3rd, you say it was apparent that questions of racial motivation would require to be investigated. They would require to be investigated by both the PERC and the Crown. Yes. Okay. You say that no one was under any doubt that this was something that required to be investigated. And when you say that, would that include the PERC? Police, Crown and PERC at the time were under no doubt about that. You say that PERC were under no doubt. What makes you say that? Over the weeks following the incident, I had a number of discussions with various people at PERC, including the Commissioner, Mr Mitchell and others, and race was always something that was covered in those conversations. So it was always part of the discussion. Is there any evidence of racial motivation during the conversations that we had? That was always something that came up. So I was confident that that was being explored. There was a meeting, I think, on the 1st of September, and we'll come to that because I think there's a file note that I'd like to take you to. Okay. But were there then, should we understand, there were other meetings? That wasn't a one-off? There were a series of phone calls, but there were also a series of meetings that we had over that period of time before the September meeting to which you've referred. And there was obviously regular contact as the investigation progressed. And these were obviously lines of inquiry that were being discussed. Yes. And you mentioned some of the lines of inquiry in this paragraph on the screen before us, but if we can go back to the beginning of May, 5th of May or thereabouts. What were your expectations at that point in time as to how the PERC would go about the task of investigating whether there was a racial motive?
I would have expected that that would be one of the lines of inquiry that they would follow, and they would look for any evidence from any witness or any other source that suggested that Mr. Bayou's race had any part in the conduct of the police officers into whom he came with contact on the 3rd of May.
So that would involve a review of statements when you say evidence
Yes.
from witnesses and evidence from any other source?
Yes.
And were your expectations as to how they should go about their task communicated to them?
We discussed them, and so we discussed that that was part of the investigation. As I understood it, they were looking for that evidence as they followed the process of taking statements from witnesses and looking at the other evidence.
Were these discussions as early as May?
Yes.
Yes, because we've heard evidence that the officers themselves didn't give statements until the beginning of June.
Yes, that's correct.
And do you recall at this distance whether there were any discussions with the PERC in the month of May as to the approach that might be taken when the officers' statements were eventually noted?
I don't think we were involved in the interview plan, as it were, what specific questions they were going to be asked. That's not something typically we would be involved in with an investigative agency, that they had a degree of discretion as to how they went about that. But in terms of the outcome that we expected, the outcome being that these were matters which would be covered appropriately, that is something that was being discussed.
Would it have been your expectation then that as and when the officers gave their statements, and we've heard evidence that initially they were unwilling to do
Yes,
so, but
recall.
the statements were provided at the beginning of June, was it your expectation, in light of the conversations that you'd had with PERC in the month of May, about the need to probe whether there was a racial motivation, and that would involve looking at the evidence of witnesses and evidence from all other sources, that those matters would be explored with the officers in their statements?
Yes, I would expect that to be done.
Now, the first written instruction to the PERC concerning race was issued on the 2nd of September of 2015, and we'll come on to look at that. But we have not had sight of any written instructions prior to that date in relation to race. And of course, your initial letter of instruction that we have looked at doesn't specifically mention race. And I wonder whether you had considered mentioning race in your initial letter of instruction.
I hadn't considered that, as I noted in my statement. In any incident which involved a black man, as this did, you would have expected that to have been done. That was part of all of the guidance to investigators. So in instructing PERC, I was conscious that whilst it was an organisation which was 2 years old, the people that I was dealing with and the people that I was instructing, most of them came from a background of policing. They had been through all of the relevant police training. They were aware of the various manuals that the police had. They had been through all of that training, and that in the criminal justice system for the past 10 years, these had been issues which had been dealt with, which had been mainstreamed. And so I didn't consider doing it because, in my view, it was entirely obvious that a black man having died in contact with the police, race would be at the forefront of the mind of any competent investigator, as it was in the forefront of our minds. So I don't think I did consider it. I think, as I've said, that in hindsight, it would have been better if it had said that. But I didn't, at the time, think that was necessary to do, because I thought it was obvious that was something that had to be explored.
So it would have been stating the obvious.
That's the view I took at the time, yes.
Les Brown, Mr. Brown, has given evidence already, and certainly he said that he said, "I don't accept it required a letter of instruction from the Crown to consider race. The letter of instruction was for an effective investigation to be carried out." And you're nodding your agreement.
Yes, that was my view at the time, was that we didn't really know what had gone on. The letter of instruction was a letter which said, please tell us what went on, and it was obvious that because of Mr Bayou's race, that was an element which had to be considered. That was consistent with every piece of guidance to any law enforcement agency that over the past 10 years or more, certainly since the Lawrence report and everything that came from that was something which I didn't think needed to be said.
We've also heard evidence from Kate Frame, and she was asked, did she consider that her initial terms of reference to investigate the circumstances of Mr Bayou's death would have permitted the PERC to actively investigate whether race was a factor. And she said that the terms of reference wouldn't have precluded that, but, and I quote, "I would have expected a specific direction from Crown Office about that." Can I invite your comment on her statement?
I would disagree with that. Firstly, the phrase terms of reference have been used, and in my mind, in sending this letter of instruction, we were not setting terms of reference or parameters for an investigation. It was not like heads of investigation, such as an inquiry like this may have to discharge. What we were doing is we were asking PERC to investigate something. So it wasn't a case of specific terms of reference and they had to work within those terms of reference. They were expected to gather evidence and follow the evidence, in my view, and that evidence would take them where it took them. So anything in relation to the death of Mr Bayou or the circumstances leading up to that, which I think are captured in one of the paragraphs of the letter of instruction, I would have expected them to follow. There was no intention to preclude following any lines of inquiry. I'm surprised if Ms Frame's given that evidence, because when PERC were set up, she was the first head of CAPD and was involved in that, and these were discussions that we had with policing and the first commissioner, that we didn't want to restrict them in terms of evidence. And so I'm always nervous when people talk about terms of reference. They are instructions so that PERC know that it's a crime-directed investigation that they're carrying out, and that gives them additional powers should that be required in terms of the statutory scheme. So I don't agree with that.
That's helpful. Just to clarify, I think it may be the case that the inquiry used the expression terms of reference and invited Ms Frame's comment, and it may not be the case that she used that phraseology, but certainly she was clear in her evidence that she would have expected a specific direction from Crown Office in relation to race.
I don't agree with that, and again, had that been expected, that could have been asked for, and that discussion could have been had, and that didn't happen.
We've heard evidence from the investigators within the PERC that prior to the letter that was issued on the 2nd of September, although they had not been directed by the Crown in relation to race, they were taking cognizance of race. And in particular, Mr McSporran was taken to his policy log when he gave evidence. We don't need to bring it up on the screen, but there is an entry dated the 9th of May, which reads, "Although not directed by Crown Office at this stage, take cognizance of any issues of race if they emerge." And the evidence was that although the PERC were taking cognizance of race wasn't a positive or proactive line of investigation. And so, for example, when the officers did give their statements at the beginning of June, on the 4th of June, the interview strategy didn't include race. They weren't asked questions about race. But were you aware of that at all?
I wasn't. The policy log isn't something I would see. The interview strategy isn't something I would see. If race was not being pursued as an active strand of investigation, that would surprise me.
Would it concern you?
Yes.
In relation to the notion that the PERC were taking cognizance of race, Mr Brown was asked about this in his evidence, and he said that to his mind it suggested that the PERC were open to it if they came across it, whereas it wasn't an active investigation. And he was asked, were your expectations on the part of the Crown that the PERC would pursue an active line of investigation, that they would, in terms of Article 14, pursue their investigation with vigour? And he said, yes, I think to be an effective investigation, those kind of descriptions are required. Would you agree with that?
I would agree with that and take cognizance. It sounds passive, so as you say, it sounds as if it arises, then you look at it and see what it takes. But in my view, best investigative practice would have required that to be an active line of investigation which was pursued, and so questions would be asked about that of almost any witness, and things may emerge that would be followed up at that point.
Now, we've heard that the first, or perhaps interim, PERC report was received in Crown Office in August of 2015. Did you read it when it was received?
Yes, I think it was actually addressed to me, if I recall, but I read it and I read the accompanying documents. I don't think it was intended that was a first or interim report. I think that was intended to be the report. And it was as a result of our reading it and considering further lines of inquiry that further instructions were given.
There's been slightly conflicting evidence from witnesses as to whether this was always intended to be an interim or first report, or whether it was intended or expected to be the final product. But do I understand that you're saying that your expectation was that this was the final report?
I perhaps wouldn't describe it as a final report. I think it was always understood that there were a series of ongoing lines of inquiry which were going to take longer than this, but I expected it to be the main factual report of what happened on the morning of the 3rd and immediately before that. So that was I think my expectation. It was always, I think, understood that there may be supplementary reports because there were bits of evidence which were awaited, etc. But the main report, which would be supplemented, would be the way I would describe it, as opposed to the final report. I think we may have expected there to be other chapters of evidence that would come subsequently to this, but this would be the piece of evidence which covered what happened that morning in terms of the factual accounts of the witnesses who were there and what they saw and what they heard, etc.
So you'd anticipated a report and then supplementary report or reports to tie off the ongoing and outstanding lines of inquiry?
That's my recollection, yes.
Okay. The report of August 2015 is 351 pages long. There are references within the body of the report to black male, black guy, threat level, terrorist risk. However, there's no mention of race, racism, racist, race discrimination, motivation, anything of that sort. That report didn't cover race discrimination, Article 14, even just to raise the issue and discount it. Would you have any comment to offer on that omission?
I think that led us to have as part of the conversation that we had after that report, that led us to the conversation about, well, what is their own race? Has that been pursued? And we asked for further information about it.
Does that perhaps take us then to the meeting of the 1st of September?
It perhaps does, yes.
2015, because the report was submitted in the August.
Yes.
Now, there is a file note in relation to that meeting, so I wonder if it might be helpful if we bring that up on the screen. Yes. It's COPFS 03585A. So the file note is dated the 1st of October, and it refers to a meeting on the 11th of September. I'm sorry, I had thought the meeting was on the 1st of September, and given that there was a letter sent on the 2nd of September, forgive me, I think I'd rather look at the letter first so that we can deal with things chronologically. I've got them out of sequence. That was entirely my fault. I'm sorry. So let's look firstly at the letter of the 2nd of September, and that is COPFS 02557. Now, this is a letter. If we scroll down, we'll see it's dated the 2nd of September. If we scroll up a little bit to the top, please. Oh, it doesn't say here who it's from, I'm sorry, it's just the Fiscal's Office address.
I think
but
it's from Les Brown from the reference. That I
you
can
see the
on
reference,
screen, yes.
LAB, and also criminal allegations against the police division, of which he was the head. It's addressed to Kate Frame. It's a fairly lengthy letter. Let's scroll to the bottom first of all, please, so that we can just satisfy ourselves that this is a letter from Les Brown. It is indeed. And Mr. Brown said in his evidence, though he couldn't recall at this distance, that it was likely that it would have been read by you before it was sent. Can you help us with that? Do you recall having seen this letter before? We'll look at it in more detail shortly.
I don't recall having seen it. I think, given where we were in the inquiry at that time, if I didn't see the letter, I was aware in general terms of what was in it. I wouldn't disagree with his evidence if he thinks I saw it, but I just don't specifically recall having seen it.
All right. Let's look at the content of the letter. That may jog your memory. Can we look at page 4 of the PDF, please? Here we are. So that bullet point near the top of the page. This letter was quite wide-ranging in terms of the additional instructions that were being issued to PERC, but it's the one that relates to race that I would like to focus on just now. I require confirmation from the Commissioner that issues of race and whether there is any evidence of racial motivation is a primary focus in the PERC investigation. The investigation should examine whether there is any evidence that any of the officers, I think that should say, involved has expressed any racist views or opinions in the past. In particular, and we perhaps don't need to look at the detail, but 3 specific lines of inquiry are then suggested: whether officers have held views in the past. There's an issue in relation to, or a reference to, an issue concerning text messaging within Fife Constabulary, and an issue concerning Alan Payton that is set out in the paragraph below. So we've heard that these 3 specific lines of inquiry reflect concerns that have been raised by Mr. Bayo's family with the Crown directly.
Yes, I think that's correct.
And Mr. Brown, in his evidence, said that this paragraph here was intended to be a general instruction highlighting 3 specific concerns. And I wonder whether that is clear from the language used, or whether there's a possibility that the paragraph might have been read as exhaustive rather than illustrative by the PERC.
That's a matter of interpretation, and how they interpreted it would be really a question directed to them. But I think the first sentence of that paragraph, which seeks confirmation that issues of race is a primary focus, that says what it says. Is are you looking at race in general terms, and it then goes on to some specific aspects of that. But I think that was intended to be a general expression. And I think that's how it reads.
We've heard that the PERC's consideration of race didn't really go beyond these 3 specific aspects. And I wonder whether, with hindsight, this was an opportunity for the Crown to have provided more in the way of guidance to the PERC, perhaps by providing additional examples of lines of inquiry, or perhaps by stating that the expectation was that they applied their own minds to the issue and perhaps reported back to the Crown in terms of how they proposed to take this aspect of the inquiry forward.
In hindsight, we could have, but again, I go back to the context, and the context is a number of discussions in which these were discussed, and the context is also that the people that we were dealing with at PERC were very experienced. They were, although PERC was a new organisation, the Commissioner was an experienced prosecutor, and the Director of Investigations and the senior staff there were very, very experienced police officers and very experienced detectives who, from my own knowledge, had dealt with very complex cases. So, contextually, I don't think that I think that we didn't give specific guidance because all of those factors were taken into account. On reflection, and given what you've told me, yes, we could have put more in. But I'd be disappointed if today as we sit here now, if a similar incident occurred, we would have to specify in the body of a letter of instruction, these are the lines of inquiry you should follow. As I understood it, PERC investigators followed the relevant policing guidance, because the police in the United Kingdom have produced lots of guidance about how you do an investigation, and that was very specific in its terms as to how you undertook one of these investigations. And in my mind, not only because they were experienced police officers in their previous careers, but in my mind they would be doing that. So I'd be disappointed if we had to specify these are the sorts of things you won't need to look for, whether it's the language of the officers before, the language of the officers after, how they've dealt with other people, whether there's anything in their past, whether there are any racial tropes or stereotypes applied in any of the material that's been produced. I'd be disappointed if we had to do that now.
You said earlier in your evidence that it was your expectation that the PERC would gather and follow the
Yes.
evidence, and that to have given a specific direction in relation to race would have been obvious,
Stating the
stating
obvious,
the
yes.
obvious. And do those sentiments apply equally
They
here?
apply to this as well.
Thank you. So that was that was the letter of the 2nd of September. If we could perhaps now move on to the meeting and bring back the file note that we looked at a moment ago. So the file note is dated the 1st of October but relates to a meeting on the 11th of September, so about a week after the letter was sent. And we can't see it unless we scroll down a little bit, but Mr. Brown's initials are at the bottom, so it appears that he's prepared this file note. We can return to the content, please. At the meeting with PERC, attended by John Mitchell and Kate Frame, together with Les Brown and Stephen McGowan on 11 September 2015 at PERC offices, COPFS officials stressed the importance of ensuring that issues of race were fully addressed as part of the PERC investigation. The importance of considering whether race had any influence in the way that the incident was dealt with as part of a wider consideration, as well as whether there was any evidence of overt racism, was explained. Now, do you recall this meeting?
I had, I think over this period of time, there were a series of meetings with PERC, and many of them were at the PERC offices in Hamilton, and they would all be attended by Mr. Mitchell and Ms. Frame. So I don't think I can isolate in my mind this particular meeting. We had a number of them.
All right. Can you assist me with what prompted the meeting at all? It does come about a week after the letter of the 7th of...
I can't recall if there
2nd
was a
September.
specific prompt, if it was to discuss the letter or if it was just to have an update on the general, a general update about where the evidence was post the letter. I don't recall that, I'm sorry.
Can I take it you don't recall the discussion and that this file note hasn't really...
I don't recall the specific discussion, and the file note hasn't jogged my memory. I do recall that we had a number of discussions in which the question of race was discussed, and we sought that assurance that have you got anything? And what was coming back to us was that they were not finding that evidence.
Okay. Taking this file note at face value, it reads that the importance of considering whether race had any influence in the way that the incident was dealt with as part of a wider consideration, as well as whether there was any evidence of overt racism, was explained. So it appears that a distinction was drawn and set out as between overt racism and influence, or perhaps
Yes.
implicit bias. But at this distance, and given that there were a number of meetings with the same personnel, you don't recall the specifics.
I don't
of
recall the
discussion.
specifics. I mean, it looks as if one of the things that we're doing at the meeting is reinforcing the message which is in the paragraph from that earlier letter, and we're reinforcing that, having perhaps had a concern from reading the report that material hadn't been covered, or that line of inquiry hadn't been covered to our satisfaction.
Now, Kate Frame, in her evidence, said that PERC had expressed concerns about the feasibility of assessing whether race had any influence on the officer's actions in the absence of any evidence of overt actions on their part, and she said that no guidance was provided on the assessment of influence, and a greater degree of direction and guidance would have been helpful. Again, can I invite your comment on that?
No further guidance was asked for at the time. I would start by saying that. This comes down to questions of mens rea, which are, again, basic concepts in criminal law. In any case, we don't know what's going on in the mind of the suspect, the potential accused. You get that from everything that goes round about it, whether it's things that they've said, whether it's things that they've done, and the surrounding circumstances. I don't understand that we were asking for anything complex or novel here. It all goes down to those questions of looking at all of the circumstances to say, what can we discern about why the officers acted in the way that they did? And you get that from all the surrounding circumstances and from a thorough inquiry, but it goes down to those basic concepts of mens rea. You never know what's in someone's mind. You get that from what happened round and about them and what they did.
Can we return to your statement, please, and bring up again paragraph 169? We've looked at this already. Four or five lines down, you refer to the Chokar reports. In the years since the reports following the murder of Surjit Singh Chokar, these were matters that were considered routinely and in every case, and this is in the context of a discussion about racial motivation. I wanted to ask you, how routinely is racial motivation considered?
It should be considered in any case where the victim is from a minority ethnic community,
Okay.
or where there's any other evidence that would suggest that race might be a motive, depending on the facts and circumstances. But in any case where the victim is from a minority ethnic community, the lesson of Chokar, where that wasn't explored, and it was put down to the theft of a gyro check, if I recall, the lesson from that was that you must explore it in every case, and not just take things at face value.
Now, we've spoken at some length about the Perk investigation. If we can turn now to the Crown investigation, and I take it then that the question of race would be considered routinely in any case where the victim was from an
Yes.
ethnic minority background by the Crown as well
Yes.
as by the reporting agency. And I wonder, back in 2015, was there guidance available to those within Crown Office as to how to investigate whether race was a motivating factor in the commission of an offence?
There would have been guidance on racial offences at that time, which had been in place for a number of years. I can't remember the specific detail of it, but there would have been guidance in relation to that, which I'm sure would have pointed in the right direction for that.
There is a chapter in the Practitioner's Handbook on racially aggravated offences,
Yes.
which we will look at shortly. Is that what you had in mind?
I had in mind that, and I think there was also a Crown Office circular which also dealt with some of these matters as well, from recollection. Because often a racial case came at summary level, and so there would be guidance in relation to that.
And was there training for staff involved in the recognition process as to how to investigate whether race was a motivating factor?
I can't recall what specific training was available, either to recognisers or wider legal staff. I recall that there had been training in the early 2000s, but I can't recall whether that was a course which repeated for new starts or what inputs people had on that, I'm afraid.
And was there guidance on compliance with Articles 2 and 14?
I don't recall that there was specific guidance at that stage, no.
Okay, training then?
There was training in the sense, so if you moved on to case preparation work and precognition work, there was a course for that. What the content of that course was and how much and whether it dealt with some of these issues, I can't recall. There was also a separate course called the Deaths Core course, which was it was about the basic investigation of deaths. And again, I'm sure that must have covered Article 2 in some way. I just can't recall specifically what it was.
We can ask other people about that.
I would have been in these courses over 20 years ago, so I don't recall.
Now, we've heard evidence, heard that evidence of racial motivation can in some instances be overt.
Yes.
So that might be, for example, someone shouting a racist slur. There's no evidence of that sort
No.
here. We've also heard that evidence of racial motivation can be covert, subtle and harder to detect.
Yes.
If you only look for evidence of overtly racist behaviour, then you might overlook more subtle behaviours that point towards a racist motive.
I would agree, yeah.
And if you only look for evidence of overtly racist behaviour, then your investigation may not unmask a racist motive.
Yes.
And if you only look for evidence of overtly racist behaviour, then the investigation might not ultimately be adequate.
I agree, yes.
Now, you say at the very bottom of this paragraph that you were satisfied the questions of race were being explored appropriately. I'm not sure whether you were satisfied that they were being explored appropriately by the PERC or by the Crown, or perhaps by both.
I think by both. At the time, I think whilst we were having to remind PERC from these documents about these things, we were doing that and we were confident. I think I was confident that those messages would land with them and they would explore that.
And so far as the Crown were concerned, what did you understand was being done within CAPD to investigate questions of race?
My understanding was that we were analysing all of the evidence that came in. We were considering what was within that, whether there was any evidence of that. We were looking at further lines of inquiry if we weren't satisfied that PERC had followed all of the lines of inquiry, and that we would look for any evidence of racial motivation or racial factors contributing to what happened. And
where did you expect the Crown to be looking for evidence of these more subtle indicators of racial motivation?
They would be in all of the evidence. So they would be in the evidence of the statements, so things which were said in the statements which might cause you to have a view. They would be in things like all of the police radio chatter, the airwave chatter, I think it was. That was all available to us. We would be looking in that. You would be looking at all of the documents that were prepared. You would be looking at the policies that I think we were in gathering. You would be looking at across the piece for evidence of that.
And at what stage of the investigation did you expect CAPD to be on the lookout for evidence of a racial motivation?
I think all of the way through you would be looking for that.
And who within CAPD was responsible for scrutinising the evidence in the way that you've described and assessing it for relevance to the question of a racial motivation?
All of those involved in the preparation of the case had a responsibility for that.
So would that include the precognosers?
It would include the precognosers. It would include Les Brown as the head of CAPD. It would also include me in terms of what I read in the reports that I read.
So far as the precognosers are concerned, we have heard that the narrative was prepared by Alistair MacLeod and Erin Campbell, and the analysis by Fiona Carnan. Would this responsibility fall to all three?
Yes.
Now, how confident were you that the team had the necessary skill set to identify evidence of racial motivation?
I had every reason to be confident. They were experienced lawyers who had been involved in large and complex cases before. I had every confidence that they were able to discharge that duty. They were they were brought in specifically because of their experience in large and complex, or certainly Mr McLeod and Ms Campbell were brought in because of their experience of large cases. So I had every confidence in them.
Now, Fiona Carnan prepared the analysis. She worked very closely, she told us, with Alistair Campbell, but he led on the narrative, she led on the analysis.
Yes.
And she gave a written statement to the inquiry as well as giving oral evidence. And in her statement, she said that prior to the date I became involved in this matter, I had no previous involvement in the investigation of deaths in police custody or following police contact. And she didn't recall any deaths that she'd been involved in investigating where race was a factor. So no experience really on deaths following police contact or in police custody, or deaths where race was a factor. And Mr Brown also gave evidence that he had no experience of investigating a death in police custody or following police contact, and had no experience of racism being a factor to consider when investigating a death in custody or following police contact, or indeed the actions of on-duty police officers. So again, limited experience, if any, in relation to deaths in police custody or following police contact and race. Given the limited experience of the analyst and her line manager, effectively, in relation to the investigation of deaths in police custody, certainly following restraint, and race being a factor, and also given the limited guidance and training that was available at that time, particularly in relation to Article 2 and Article 14, with the benefit of hindsight, do you think the CAPD team were as well equipped as they might have been to take on this task?
The staff involved were very experienced, so they were very experienced generally. In terms of that, I think if I address your question this way, I'm not sure where else in the organisation that experience of deaths in custody or deaths with a racial factor actually lay. I cannot recall any other incident of this nature. The only thing I can recall that might be analogous in terms of a death was the Park Inn incident, which was a completely different nature. But it did involve, a death involving the police. And there was a limited number of cases that we had where there was a death in police custody, where the person was from a minority ethnic group, and in particular where there was contact with the police, as opposed to the death being for some other factor, suicide or mental health or something like that, where there was no actual contact. I don't recall many cases of that nature, so I'm not sure that we had a population of lawyers in the organisation who could have come in and done that. That perhaps then goes to your question about guidance, and I can't recall specifically what's in the guidance. It may well be that guidance requires to be looked at, and there needs to be more guidance in that area. But I don't think there was another group of people who could go and do that, who had experience of a similar type of case. I think Mrs Carlin is a very experienced lawyer, one of the most experienced. She's got 30 plus years as a deputy, probably almost 30 by the time of this incident. As I said, Mr McLeod and Ms Campbell were very experienced, and so you sometimes have to look at things that you've never looked at before. I had confidence that they would pick up and be able, from the guidance and from the guidance that they were being given, that they would be able to look at that and explore it. I don't think there were other people we could have selected who had more specialist expertise or experience in the area.
So if there was no one within the organisation who was, if you like, better placed than the team who were assembled and brought together for the purposes of carrying out the Crown recognition, was it recognised that this particular case introduced new challenges, new areas of work, and that there was perhaps a gap in experience?
I'm not sure the gap in experience was something that we discussed. It was recognised that this was and that's why I referred to it, sensitive, high profile. Some of the sensitivity came because this was not an everyday occurrence. This was an unusual case, and we would have to work our way through it as an unusual case from first principles. Whether we saw at that time that there was a gap in experience, I'm not sure. But in reflecting and coming here today, I can't think of other cases. The other factor in terms of not having people who had done this before is that all of the CAP cases had until 2012 been done by the area procurators fiscal. So it was a very small group of people who dealt with those cases, and most of that group of people, when we restructured, and for various reasons had left the organisation. So the vast majority of people who had been dealing with the complaints about the police on a regular basis, they had all gone by this point. And so we did recognise that. We did recognise that although we had a specialist team, that specialism was one which was developing, as opposed to on day one being a fully fledged team that could deal with everything and had experience of every aspect of dealing with the issues that might arise in terms of police criminality.
So was the expectation then that this experienced team, who perhaps didn't have experience in relation to deaths in police custody or following restraint or looking for race or racial motivation, was the expectation that they'd go back to first principles?
That was my expectation, yes.
And draw on their existing experience and apply that experience to this new set of challenges and circumstances. Yes. Was any thought given to whether there might have been benefit in, for example, approaching the Crown south of the border, or perhaps looking at, I believe there are IPCC guidelines on investigating discrimination, including race discrimination, that were published in, I think, 2015, drawing on the experience of other jurisdictions and other investigating authorities from perhaps larger jurisdictions who might have had more experience of dealing with this type of case?
No thought, no. We didn't give think to that, or I certainly hadn't given thought to that, no.
Do you think, with the benefit of hindsight, that is an exercise that might have proved to be fruitful and helpful to the team?
I certainly think it's an exercise that we could have done and explored. Whether it would have been fruitful, I'm not sure. There have been all sorts of confidence issues in various investigations in England and Wales, as well as the matters that we're dealing with here. So how fruitful it would have been, I don't know, but I think in terms of exploring that as an avenue, that could have been something that we did. But it wasn't something that we thought about at the time, to my recollection.
Now, Fiona Carnan prepared the analysis, and there is no consideration of race in the analysis at all. She has been asked about her approach to race, and what I would like to do is bring up some passages from her written statement and tell you a little bit what she said in her oral evidence, then invite your comment on the approach that she took. I wonder if we can bring up Ms Carnan's statement, please. It's SBPI 00379. SBPI 00379. Oh, I beg your pardon, sorry. And can we go to paragraph 45, please? You'll see that she has copied over the questions into the document that contains her answers. So the question that she was asked was, to what extent was race a factor in your analysis of the actions of the police officers? In your view, was this sufficient to inform Crown Counsel of the impact, if any, that Mr Bayo's race had on the actions of the police officers who engaged him? I was concerned with considering whether the actions of any of the officers, either individually or collectively, amounted to criminality. My focus was on the actions of the officers during the period of their engagement with the deceased and the evidence of how they conducted themselves thereafter. I did not identify criminality on the part of any of the officers involved. Had I identified criminality, it would then have been part of my analysis in respect of criminality to consider whether the conduct was racially aggravated under Section 50A1B of the Criminal Law Consolidation Scotland Act 1995, or whether race was a motivating factor that would amount to an aggravation of the conduct of the accused officers in terms of Section 96(2) of the Act. If we could also look at paragraph 38, please, which expands on the approach that she took here. She was asked to explain her involvement in gathering and analysing evidence in relation to race. And she said, "I was not involved in gathering evidence about race. If my analysis of evidence had established that there was sufficient evidence to support criminal charges against any of the officers, the question of any racial motivation or intention would have been addressed at that stage. Since the analysis of evidence did not identify criminality by any officer, the question of racial aggravation did not arise, since no offence had been identified." So in her evidence, I took her to both of these paragraphs and then said, am I right to understand that essentially this was a two-stage process? You would look for evidence of criminality first, and if you found criminality, if and only if you found evidence of criminality, then you would go looking for evidence of a racial aggravation or motivation. And she said, that's right. I said, does that fairly set out the approach that you took? And she said, yes. Can I ask you, and I appreciate I've given you quite a lot of information, if you'd like to see that on the screen again, please, just say, but how does this two-stage process fit with your expectation of what the Crown's approach to scrutinising the evidence for indicators of a racial motivation would have been?
There are perhaps I wouldn't describe the way I would approach this as a two-stage process. It all depends on the evidence, but depending upon the evidence in a case like this, where you're considering whether or not the violence that we came to understand that the police officers used was justified, questions about why the violence was used, which would be tied up with the motivation, and so I'm not sure that it's a strict two-stage approach that you say, was there an assault, and if you tick the box that says yes, there is an assault, well, was that racially motivated? I think it's slightly more subtle than that, so I wouldn't describe the approach that I would go through as being a strictly two-stage process in that way. I think that when you're looking at the justification for the officer's actions and whether that was a justified assault or not, you would probably have to look at why they were doing it. And so if they were doing it and if they had race in their mind in any way, that would be a factor that you would take into consideration in terms of whether the violence was justified. It may not amount to, you may not come to a different conclusion on criminality, but I would analyse it in a slightly different manner when you're looking at it in that way. So not a two-stage approach, no.
Does it concern you at all to hear that that was the approach taken?
I'm not sure, because I've only seen the narrative and analysis when I was preparing my statement, and that was some time ago, so I can't. It would concern me if we would have come to a different conclusion depending upon that, and I'm not in a position to say whether or not we would have come to a different conclusion looking at it the way I've described as opposed to the way that Mrs. Cannon says that she's described it. If we'd come to a different conclusion as a result of that, that would concern me. Because of the involvement of Crown Counsel and the Victims' Right of Review, I'm relatively confident that we wouldn't have come to, and therefore any concern I have would be lessened by that, but I certainly would have approached it in a slightly different manner.
I appreciate that you didn't see the narrative and the analysis at the time that they were prepared in Crown Office, because that was after you had moved on to other responsibilities. And I understand that you saw them for the first time and they were provided as part of a package of documents that were made available to you for the purposes of answering your Rule 8 request. Please take it from me and I will be corrected if I am wrong. There is simply no analysis of race in the analysis section of that recognition at all. Does that surprise you?
as I said, if it had been me that had been writing it, I would have written it in a different way. And so from that point of view, it wouldn't have been what I've done, so I'm surprised at that. But whether or not it was fit for purpose in that sense or not, I'm unable to say. Approaching it in the way that Mrs. Carnan has, I can understand why she hasn't referred to race if she's looking at it, if she's looking at whether a crime's been committed. In the second, you've shown paragraph 38, I think it's paragraph 46, when she refers to...
It's 45, I think.
45, when she refers to the section 50A crime, I mean, that's all about race in its own way. That's not an aggravation to another substantive criminal offence, and so you would have to look at and analyse race if you were considering that at all. So I'm not actually sure what she means.
Well, this might be...
It may be that she simply hasn't found that, but I don't know.
All right. This might be a convenient point to look at 50A, to look at the text of it. But I'm conscious that we normally take a break at about 11:30. I wonder if this
Yes.
is
Oh, we'll have a 20-minute break at this point. Ms. Thompson.
Thank you. Before the break, we had mentioned in passing sections 50A and sections 96 of the 1995 Act, and I think it might be convenient to turn to them just now.
Okay.
Now, they're helpfully set out, in fact, in a Crown Office document. It's a chapter from the Practice Handbook, the one I mentioned earlier, on racially aggravated offences, COPFS 06411, please. Now, you'll recall that before the break, I took you to Fiona Carnan's statement, 2 paragraphs within her statement, and then to the evidence that she gave before the inquiry. We can only have one document on the screen at a time, but just as a reminder, she said in her statement, had I identified criminality, it would then have been part of my analysis in respect of criminality to consider whether the conduct was racially aggravated under section 50A1B, or whether race was a motivating factor that would mount to an aggravation in terms of section 96(2). So this is the Precognoser's Handbook, Chapter 44, Racially Aggravated Offences, but I'm really only looking at it today for the purposes of bringing up the relevant text of the legislation. So I wonder whether we can look at page 3 firstly. Can we scroll down a bit, please? There we are. So let's look firstly at section 96(2), please. Section 96(2) defines racial aggravation for the purposes of section 96 in the following terms. An offence is racially aggravated if, at the time of committing the offence, or immediately before or after doing so, the offender evinces towards the victim, if any, of the offence, malice and ill will based on the victim's membership or presumed membership of a racial group, or the offence is motivated wholly or partly by malice and ill will towards members of a racial group based on their membership of that group. And if we scroll down, keep scrolling please, we will see that there's a requirement to libel the aggravation and that evidence from one source is sufficient to establish the aggravation.
Yes.
And we should also see, I think slightly further down the page, that where the aggravation is libelled and the person is convicted, the court shall take the aggravation into account in determining the appropriate sentence.
Yes.
So that is section 96, and for that section to apply, there has to be evidence of an offence.
Yes.
And in addition to that, evidence of racial aggravation.
That's correct.
And a single source for the racial aggravation will suffice.
That's right. Yeah.
Let's compare that now to section 50A, and that I think is set out on page 2 of this document. If we can go up a little bit, please. Sorry, other way. So section 50A creates a statutory offence of racially aggravated harassment and racially aggravated behaviour. Section 50A1 provides that a person is guilty of an offence if he pursues a racially aggravated course of conduct which amounts to harassment of a person. And we can perhaps skim over that because I don't see that has any bearing on the circumstances here. But let's look at the alternative. We'll see at the end of 50A1A subparagraph 2 the word or, so these are alternatives.
Yes.
So a person is guilty of an offence if he acts in a manner which is racially aggravated and which causes or is intended to cause a person alarm or distress. So a person is guilty of an offence if he acts in a manner which is racially aggravated. Yes. And if we scroll down the page a little, please, to the definition of racial aggravation for these purposes. A course of conduct or an action is racially aggravated if immediately before, during, or immediately after carrying out the course of conduct or action, the offender evinces towards the person affected malice and ill will based on that person's membership or presumed membership of a racial group, or the course of conduct or action is motivated wholly or partly by malice and ill will towards members of a racial group based on their membership of that group. So if we could read this section short, in effect it criminalises behaviour that would not necessarily be criminal otherwise.
Yes.
And it does so where two criteria are met. Firstly, a person acts in a way that causes or is intended to cause another person alarm or distress, and their actions are racially aggravated.
Yes.
And the definition of racial aggravation is in two parts and includes the action being motivated by malice and ill will towards members of a racial group.
Yes.
Where these two criteria are met, then behaviour that might not otherwise be criminal is criminal.
That's correct.
So, when considering the applicability of Section 50A(2), the person carrying out that assessment will require to consider whether an individual's behaviour has been motivated by malice and
Yes.
ill will. So their state of mind will become relevant.
Yes.
And as you said earlier, we cannot look inside people's heads. It's a question of looking at what was said, what was done, and the surrounding facts and circumstances.
That's right. Yeah.
And so evidence about racial motivation would have been relevant to the assessment of whether an offence had been committed under Section 50A.
It would have been, yes.
Okay. And would you have expected an assessment as to whether there was evidence supportive of a contravention of Section 50A to have been included in the analysis of the evidence in this case?
It's difficult to say whether I would have expected that to be in and excluded or not without having seen the narrative. Again, it would have been better if that had been covered because it is given that race was a factor all the way through this, given that that would be part of the consideration that you would have to give, and given that there's a specific offence, it would have been better if that had been covered somewhere in the recognition, and I think you've told me it wasn't.
It would certainly demonstrate that the analyst had applied their mind to whether
Yes.
the criteria for Section 50A(2) were met or not.
I agree.
So irrespective of the conclusion that they reached, even if they reached the view that there was no criminality in terms of Section 50A(2), it might have been helpful with the benefit of hindsight
I agree.
for their thinking to have been set out
I agree.
in the analysis. So returning to the two-stage process that Fiona Carnan adopted, where she looked first for evidence of criminality, and because she didn't find any, she didn't then go further to consider whether there was evidence of a racial aggravation. Does that not rather put the cart before the horse?
In terms of the Section 50A offence, it does, yes. It's a standalone offence. I only saw the statement, the passage from her statement briefly. I had anticipated that she might have been perhaps talking about the Section 96, and that still wouldn't have been my way of looking at it, I don't think, for reasons I can explain. But yes, I agree with the proposition that you've just put to me.
Would you like to see her statement again?
No, I don't think so.
All right. And certainly the approach, the two-stage approach that she told us she had adopted wouldn't detect behaviour that might only be criminal by virtue of Section 50A.
Not in that way that she's explained it, no.
I want to move on to look at other aspects of her evidence with you, and I wonder if we can return to her second statement, SBPI 00462, at paragraph 8. Where she was asked whether she was aware of any racial tropes being used by any of the response officers in their statements. Would they have been relevant to her analysis? And she said, I have made no reference in my analysis of evidence to the use of racial tropes or negative stereotypes being used by any of the response officers in their statements. However, it is unlikely that I would have done so, since the use of racial tropes is not criminal. And sorry, can we scroll down just a little bit, please? If we stop there, maybe 3 or 4 lines from the top. Evidence about negative attitudes of officers to Mr. Bayo's race would not be relevant to the analysis unless criminality was identified. So again, a suggestion that a 2-stage process was taken, and that the use of racial tropes was not criminal and would not have been relevant to her analysis unless criminality was identified. Do you have any concerns about that approach?
Looking at that statement, evidence about negative attitudes of officers to Mr. Bayo's race would not be relevant unless analysis of criminality, or unless criminality was identified. I don't agree with that statement. In certain circumstances, negative attitudes could be criminality in and of itself, in terms of Section 50A that we've just looked at a moment ago.
And certainly this approach will not identify the sort of behaviours that are criminalised by Section 50A.
That's a possibility, yes.
If one were to leave out of account racial tropes and things of that sort.
Yes. All of that could go to Section 50A.
There was also evidence available at the time that Ms. Carnan prepared the analysis that some of the officers were concerned that they were attending a terrorist incident.
Yes.
Some made reference to an increase in the terrorist threat level to severe.
Yes.
And Ms. Carnan explained in her evidence that she had fact-checked that and confirmed that there had indeed been an increase, a recent increase in the threat level to severe. Now, the first officers on the scene were Constables Walker and Payton, and their statements were available to her. I'll tell you what they had to say on this subject, and then I'll read to you a passage of Ms. Carnan's evidence and invite your comment. We can perhaps take this off the screen for now, thank you. Constable Walker said in his statement, the one that was given to the PERC, "It did cross my mind that he was doing this to get the police there, bearing in mind we're on a severe threat level for an attack on the police." And Ms. Carnan agreed that the severe threat level referred to by Constable Walker related to the threat of a terrorist attack. And Constable Payton said that it ran through his mind that this male could be part of a terrorist plot. And as events unfolded, and at a point in time where he'd been incapacitated by his own spray, at that point in his statement he said, "I kept thinking about the Lee Rigby boy, the soldier who was killed." So when she gave evidence, Ms. Carnan was reminded of what Walker and Payton had said in their statements, and she was asked, "Now, as part of the process that you went through in your analysis and in ensuring Article 2 and 14 compliance, did you consider why the possibility of terrorism crossed their minds?" She said, "I asked the question, although I think it had already been answered, why they had considered terrorism, because they had two briefings in the early months of 2015. And did you consider whether they would have thought about terrorism if Mr. Bayo had been white? No. Did you consider whether they thought about terrorism every time they went to a knife call? No. And did you consider why Constable Payton thought about Lee Rigby in particular? I simply noted his position. You didn't give thought as to why he thought about Lee Rigby. I didn't interpret it as being influenced by race. No. She was asked, did you consider whether Constable Payton would have been thinking about Lee Rigby if Sheku Bayo had been white? And she replied, I didn't ask that question. She was asked, did you consider whether there was evidence from which the inference could be drawn that the colour of Mr. Bayo's skin was relevant to their concern that the incident was related to terrorism? And she replied, I did not make that assessment. Can I invite your comment on that chapter of her evidence?
So that information about was this a terrorist incident, that was available at the very earliest point in the case, and I recall that. My own view is it would have been relevant to ask why it was that they thought it was terrorism and to consider whether Mr. Bayou's race had anything to do with that. And whether or not, had Mr. Bayou been white, they would have wondered the same thing. That's a relevant question.
And where might an analyst have looked to find the answers to those questions?
In the evidence as a totality.
Might you have given consideration to instructing the PERC to take supplementary statements from the police officers?
I wouldn't have started at that. I would have started not at the police officers but round and about that if I was concerned that it might amount to a Section 50 because you would get involved in the rights of potential suspects. But so I would certainly involve asking further questions to see if I could discern from the surrounding circumstances. I think, in practically speaking, in terms of what might be admissible in future, actually asking the officers, what did you have in your mind at that point, might have been a difficult thing to do. Because if you were actually asking that, you might be moving on to some sort of suspicion. But I think, looking at that again in the round, there has obviously been some sort of look about it, because she refers to the threat assessment, but whether there were further steps that could have been taken with that, you would certainly look to do that.
So an approach to the officers might have been problematic for the reasons you've outlined. If suspicion had crystallised or started to form, those statements might have been, if they were given, might have been inadmissible. So it would have been a question of discerning from the surrounding facts and circumstances.
Yes,
and can that involve a process of perhaps drawing inferences?
Yes, it would.
Fiona Carnan was then asked, did you consider whether there was evidence from which the inference could be drawn that the colour of Mr. Bayou's skin was relevant to their concern the incident was related to terrorism? She said, I did not make that assessment. It was then brought to her attention that Constable Good had also thought about Lee Rigby. Constable Good, in her statement, said, I was also thinking at that point of the Lee Rigby incident in London, mainly due to the fact of the coloured male and the potential terrorist connotations. So it appears that Constable Good did make a direct link between the colour of Mr. Bayou's skin and the potential terrorist connotations. So Ms. Carnan was asked, did Constable Good's statement not perhaps cause you to wonder whether others who also thought about terrorism in Lee Rigby had done so because of the colour of Mr. Bayou's skin? And she said, I have to say no, it didn't. Do you have any concerns about that?
As I've said a moment ago, I think these are all relevant factors that ought to have been looked at, particularly if the other officer had made a direct link between the question of terrorism and the colour of Mr. Bayou's skin.
She was then asked some questions around whether the link that Constable Good made to terrorism was reasonable or whether it might have been indicative of racial stereotyping. Did you consider whether the link she made was reasonable or whether it might have been indicative of racial stereotyping? And the answer was, I considered it was not unreasonable given the briefings. Was it indicative of racial stereotyping? Possibly. And she was then asked, you're saying that, are you saying that now with the benefit of time to reflect, or did you think that at the time? I don't think I thought it at the time. I then said to her, even though she said in terms that she'd made a link between the colour of his skin and terrorism, yes. At the time you didn't think of that as racial stereotyping. With the benefit of hindsight and reflection, your evidence today is that it could be indicative of racial stereotyping, yes. And if it had occurred to you at the time, or if you had thought about it that way at the time, is it something that you might have included in the analysis? It's possible, yes. Again, can I just invite your comment on that?
As I noted, I would have expected it to be there.
She was then asked about other possible lines of inquiry, firstly concerning the use of language. I said to her, "I'm sure you'll be aware of racist stereotypes in society, that black men are more violent, unpredictable, aggressive. You will have come across these stereotypes, I would imagine." I have. "And did you examine the officers' statements for language of that sort?" No. "And did you consider patterns of behaviour, whether, for example, they had used their sprays or drawn their batons at previous knife incidents?" No, I was simply concerned with this incident. "Did you consider whether they treated all knife calls as potentially terrorist-related?" No, that wasn't a question that was asked. "Did you consider looking for comparator evidence, for example, looking at Walker, Payton and Tomlinson's history of use of spray or Tomlinson's history of using force involving a baton, with a view to establishing whether those officers had ever used sprays or batons before?" No. "Or whether they had used sprays or batons when detaining a white suspect?" No. "Did you consider whether the speed with which the officers elected to use force against Mr. Bayo was because he was black?" She said, "That wasn't my understanding. I think I've explained in one of my answers. My understanding of their perception was based on a whole lot more than the colour of his skin." Okay, "Did you consider whether Constable Walker and Constable Payton's decision to opt for a hard stop may have been influenced by Mr. Bayo's race?" Again, we didn't cross the threshold in criminality, so that wasn't a consideration per se. So she was candid in her oral evidence that these questions simply were not asked. And again, I would like to just invite your comment on that.
They are all relevant questions. So I've referred to looking at the totality of the evidence. Those would be questions that you would ask, and the answers to those questions would be part of that totality, which I would expect us to look at. So they're all relevant questions.
At the end of paragraph 169 of your statement, you said, "I was satisfied that questions of race were being explored appropriately." What steps did you take to satisfy yourself that questions of race were being appropriately explored within CAPT?
In terms of all of the conversations I was having with Les Brown, he was alive to questions of race, and we had been alive to questions of race in the Perkin investigation. So those were the steps I was taking to satisfy myself of that. And I was also relying upon there being a very experienced team of people who were looking at it, subject to the caveats that we discussed about their experience in racial matters, but it was an experienced team of lawyers who were looking at the questions.
And with hindsight, do you consider that questions of race were being explored appropriately?
I think in the evidence this morning we've identified a potential gap, yes.
So with the benefit of hindsight, did the Crown investigation take all reasonable steps to unmask any racist motive?
I think there are further steps that could have been taken.
Was the investigation adequate?
I think you have to look at the investigation in the round, and so that's a difficult question for me to answer. But there are certainly further steps that could have been taken in that analysis of whether or not some of the factors, such as the apparent assumption, if I can call it that it might be a terrorist incident because of Mr. Bayo's skin, that should have been explored further. So the adequacy of the full investigation is difficult for me to answer, but there are certainly further things which could be done.
And could the race aspects perhaps have been investigated with more vigour?
They could have been, those questions could have been asked, and that would have meant it was more thorough.
I want to move on to a separate but slightly related issue. We've spoken about Fiona Carnan's personal approach to the analysis being a two-stage process, but I want to move on to discuss with you now what has been described by witnesses as an incremental approach being taken. Fiona Carnan said in her inquiry statement, and I don't think we need this on the screen, that it was not part of her remit from Mr. Brown to consider whether there were grounds for an FAI. My role was restricted to an analysis of evidence in respect of any potential criminality by the police. So she considered that she had a limited remit to analyse whether there was evidence of criminality by the police. Mr. Brown was asked about this too, and I wonder if we can bring his statement up. It's SVPI 00419, paragraph 105. Mr. Brown explained in his statement. I'm afraid I don't have the corresponding question, but I think this speaks for itself. He said a key element of the incremental strategy approved by the Lord Advocate was to separate out and resolve the issue of potential criminality, and to get to a point where Crown Counsel could take a decision in this regard with the necessary confidence, thus permitting the investigation to move forward to other areas in anticipation of an inquiry whose forum had yet to be determined. It had been hoped initially that the necessary further inquiries could be completed relatively quickly. The recognition that was requested by Crown Counsel was created for the limited purpose of enabling Crown Counsel to take a decision on potential criminality. On potential criminality, but was not intended to be the end of the investigative process by the Crown, particularly in relation to race and implicit bias, and further detailed inquiry would likely have been undertaken had an FAI been instructed. This would, in my opinion, have been highly likely to have required recognition of the police officers involved, where their approach to the incident would have been probed, scrutinised, and evaluated. So here, in his statement, Mr. Brown sets out an incremental approach whereby only criminality was addressed in the recognition, yes, in anticipation that after the prosecutorial decision had been taken by Crown Counsel, the possibility of an inquiry of some description would be revisited. He was asked about this in his evidence and was asked by the chair what sort of things would be left for further investigation in the event no proceedings were taken. And he said we'd be looking at the wider issues that could be explored at an FAI, and I was of the view that could include factors such as race and exploration with the officers of their consideration. He was then asked by the chair if he could provide any other examples of issues that would be considered at stage 2, and he said wider issues of race. So it appears that the only issue that was effectively held back or held over for the second stage of the investigation was race. You frowned in response to that. Were you aware that this approach was being taken?
So I was aware that the approach to this, and this was typical of our approach to deaths where there was a possibility of criminal proceedings and a fatal accident inquiry, was that we would try and address the issues of criminality first and make a decision on that criminality, which would include, if required, running a trial before we concluded our consideration of the way in which we would present the evidence before an FAI. That was typical of our approach. That's an approach that, to give a recent example, was also adopted in the M9 case, where there was the criminal proceedings against Police Scotland, and then the fatal accident inquiries. The evidence is only relatively recently concluded. There are other examples that I could go into where we've done that. That approach, Les has called it an incremental approach. I call it a linear approach, where you take the two issues separately as an issue which has been the subject of some criticism because of the delays that are said to have been caused by it, and it's an approach that certainly in between 2021 and 2023, when I was Deputy Crown Agent for serious casework, it was an approach which, in conjunction with the direction of Lord Advocate, we were trying to change so that we did the two investigations, the criminality and any wider matters in parallel. I was not of the view that what was being held back was consideration of race. Race, insofar as it was relevant to the question of criminality, was something that would be covered. But there was always going to be a further inquiry, and I think we'd stated publicly from an early stage there'd been an FAI. There came a time, and I can't remember exactly when, that we thought there were matters which went beyond the precise cause of death, which have gone into the thinking behind there being a public inquiry today, in order that the state's Article 2 obligations were satisfied. So, in my view, there was a whole series of other questions. The approach of organisations to race, out with the context of the criminality was one of them. The whole post-incident way that this was approached in terms of post-incident management by the police and others. There were a whole series of other factors which are no doubt part of the terms of reference for the inquiry. But it was never my understanding that race on its own was an issue that was going to be the thing which was held back. Race was always going to be, to my mind, something that was going to be assessed insofar as it was relevant for the purposes of determination of whether there had been criminality. And it wasn't, to my mind, just race that was a factor. I'd say it was post-incident management, it was the way the families were dealt with, there was a whole series of wider factors which, as I say, when we began to think that through, they went much beyond the cause of death, which is really the factor which, in terms of the four corners of the 76 Act, a sheriff could determine on at any fatal accident inquiry.
Mm-hmm. In fairness, I think what was said in evidence was not so much that race was held back in its entirety, but that it was considered insofar as it was relevant to considerations of criminality, but that the exploration of the question of race was not exhausted within the precognition process, and that wider issues of race would be considered at a later stage.
Yes.
I don't have the transcript before me, and I'm paraphrasing. I will be corrected if my summary is inaccurate, but I just wanted to clarify that I don't think that there was a suggestion by anyone that race had been left out of account. It had certainly been considered by CAPD to the extent that they considered it to be necessary for the purposes of looking at criminality, but I think it was recognised by Mr. Brown that certain issues would require further exploration.
Yes, I think that's fair, and I would agree that there would be further issues of race that would be required to be brought before the further inquiry as we saw at that point.
And you mentioned that there had been discussion in recent years about an alternative to the linear approach, where you perhaps have two inquiries running in tandem or in parallel.
Yes.
What was the outcome of those discussions? Have procedures been changed?
Procedures have been changed. So, in some of the cases that we had, and we were looking at this primarily in the Health and Safety Division, because that's where often we have issues of criminality, and because it's often a workplace death, a mandatory fatal accident inquiry, and that's where we're looking at this first. And so we have approached those cases in a different way, in that the analysis of evidence is not limited to the criminality, that things which will be relevant to a fatal accident inquiry will be looked at and analysed at the same time, perhaps not quite in the same depth initially, and the focus will still be the criminality, but I think the linear approach was such that things were often simply put to one side and there was no analysis of all at that time for the purposes of the subsequent inquiry, and that clearly caused delays, because you would have the criminal proceedings. Once you initiated the criminal proceedings, the timescale for them was out with your control. It could take some time because of the complexity and nature of some of the charges, and you would then be picking it back up some years after the original incident, and that wasn't satisfactory. And as I say, there are some determinations which are published in which the sheriff who heard the FAI does comment upon that. So that linear approach is not one that we're adopting now, very much driven by being conscious that the timescales that was leading to for the determination of the fatal accident inquiry to issue, sometimes in important matters of safety, wasn't satisfactory and was taking too long.
And of course there's a responsibility in terms of Article 2 to ensure an investigation is prompt.
Of course, yes.
And this linear approach, as you've described it, effectively builds in delay.
Yes, it does. See, it was thought to be essential in some of these cases because often the same factual matrix will be relevant to the criminal proceedings and the FAI. And I know in the past, going right back to the start of my career, we've looked at whether or not we can have the FAI first, and there's always been a concern that in some way that will prejudice the trial because there'll be the testing of the evidence. And I think that approach then led to us not simply not having the fatal accident inquiry before the trial, but actually, in effect, pausing some parts of the investigation until the trial proceedings had been completed.
And you say that this new approach, the parallel inquiry approach, if I
Yes.
can call it that, was initiated in the Health and Safety Division. Has it now been rolled out to other departments?
So it's SFIU and the other. SFIU, Health and Safety Division, and the Custody Deaths Unit in terms of prison deaths, which is another area where some of these delays had become apparent. They are all now having that same approach.
And these are the departments,
These are the departments
that would be
these
dealing
are the
with
relevant parts of Crown Office in
Yes.
terms of the way we structure ourselves that are relevant to that. So that's the approach that we're trying to take in these cases now.
Do you see any benefits from the new approach?
I'm not sure if we have had. I'm not sure if we've had any cases where we've now completed the journey of the cases, because this isn't within the last 2 years to 18 months that we've been doing this probably. But the clear benefit is the timelines and the journey times to final determination by the sheriff, because that would be what it is. It would be the final determination and the closing of the FAI will inevitably shorten as a result of that.
John Loke has also given evidence this week, in fact, and he was unaware that this incremental or linear approach had been taken, and he was asked for comment. Again, I'd like to share a passage from his oral evidence, so this won't come up on the screen again, I'll just read it to you and then invite your comment. He said, "What I would expect to happen is that an investigation would identify a number of issues which needed to be considered. And I said yesterday that it was clear, I think, to all of us who were involved in those initial days that the question of criminality was an immediate or obvious issue which would need to be explored in the investigation, and in simple terms was an immediate priority. There may be wider issues which relate to broader learning which would come out of a fatal accident inquiry or an inquiry of this nature, but the priority would be to reach a decision on the criminal aspects as quickly as possible. I would not expect that would mean that those individual elements would be isolated off from each other and dealt with one at a time. The investigation, I would expect, would have an understanding of all of them and be trying to make progress on all of them at the same time as perhaps identifying particular priorities. So I'm not aware of an investigation where we would take a compartmentalised approach and say, well, we're only going to look at this and we're not going to look at anything else until we've finished looking at this. I think our approach, as much as possible, is to progress the whole investigation. You may need to progress parallel investigations in 2 separate teams at the same time, rather than allowing one team to reach a conclusion before the other team then takes over. That just simply builds a delay into the process. So, for example, you wouldn't want a team looking at a criminal investigation and no one else dealing with broader aspects that I've referred to until the team had finished. You would try to make sure that there was sharing of information and progress on all aspects at the same time. So he has set out, in effect, the parallel inquiry approach that you have described as now being applicable within the relevant departments in Crown Office that deal with death investigation. And he spoke about the need to avoid delay and the parallel approach allowing both parts of the investigation to progress at the same time. I'll invite your comment, although I think that his evidence seems very much to chime with the picture that you've just painted for us as to how things are done now.
I agree with what he says in principle. You should do them. You should do the investigations in parallel. The same facts will often be, the factual matrix will be the same across both things. There may be different aspects, and certainly for a fatal accident inquiry, you will be presenting the evidence in a different way to different forum, different evidential rules, etc. So there's a whole aspect of that you would be progressing differently. So I agree with him. It is not the way that we did it in the past, however, and as I say, I've given a couple of examples, but there are many more where we'd adopted that, as I've called it, linear approach. I think Liz Brown's called it incremental in the passage that you put to me. Another part of the reason why we adopted that, I think, was resource-based, because it is more resource-intensive to be doing to be looking at the two different fora at the same time. And so I think that was also part of the reason why we ended up where we ended up in that unsatisfactory linear approach that I've described.
And the way that it's done now, is all of the work done within the same team, or do you have two completely separate teams working in parallel?
In the custody deaths team, which is the first example I gave, that's one team and that does both aspects of it. I think that's the same in the health and safety case, and in some of the cases I can think where I was involved before I left serious casework, they were being done within the same team. It may be that there are different people on the team who have got different roles, and some people may have a different focus during that.
So the custody deaths team, is that where a case such as the death of Mr. Bio would sit today?
That's a difficult question to answer. The custody deaths team at the moment is dealing with prison deaths or deaths in police cells. I think a case such as the one that the inquiry is dealing with is one which would demand a bespoke approach again, hopefully taking on board the lessons that we've learned. It may be based around about the custody deaths team. I've never paused to think about that. That is probably where you would put it, because it would have, I think, the right experience of looking at the state's Article 2 obligations in sharp focus, the way in which Mr. Bio's death involves. But I've never actually thought that through.
And you said that it can be more resource intensive, effectively running two inquiries in parallel, but you did also say that quite often the same factual matrix will be applicable, whether you're looking at criminality or a fatal accident inquiry. And I suppose in the circumstances of this case, what happened would be relevant in both fora, use of force and the decision making around use of force, cause of death, and race would also be relevant to both. You mentioned the M9 fatal accident inquiry having recently concluded its evidence. You said, I think, that it was run as two parallel investigations.
It was run as two parallel investigations, yes.
If I recall...
Sorry, it wasn't run as two parallel, it was run as a linear investigation.
It was run as a linear investigation.
And that I think, explains why we've just finished the evidence in the case. I see. I think that was also a 2015 incident.
It was. I think I misheard you, Mr. McGowan.
Yes, to clarify, they were linear as well. And
that clarifies the matter. I think I misheard you, and I had wondered why one death might be linear and the other would be parallel, given their proximity in terms of timescale.
This is something since it was in that period, 2021 to 23, when I was the DC serious case. Well, that was when we were taking that forward.
Thank you. I had taken you to Mr. Logue's evidence just to complete that passage. Even though an incremental approach was taken in this case, Mr. Logue agreed with the chair to the inquiry that you could not consider the question of criminality without considering the question of race. He said he would have expected CAPD to investigate race as part of their exercise of investigating criminality, that you would have to look at race in order to ascertain whether there was any evidence that did have a bearing on criminality. He would see that as part of a thorough investigation of the kind that would inspire confidence in the family. Is there anything in that chapter of his evidence that you would disagree with?
No, not at all. I agree with it.
Mr. Logue was also asked if the inquiry were to be split in this linear fashion, where would the wider issues be explored? And he said he anticipated that they would remain with SFIU. Did you anticipate the investigation being returned to SFIU following the prosecutorial decision?
I don't think I ever considered that at the time, but no, I would have anticipated that insofar as possible the same people would remain with the case. Because otherwise it just builds in further delay. Obviously an investigation such as this generates a lot of material, statements and other evidence to move the case around. would seem to me to build in a whole series of months as a new team got up to speed with the issues. That would for me be unsatisfactory. So I don't think I ever thought about this at the time, and I think that's probably because before I left the case we got to the point where we envisaged that there would be a public inquiry as opposed to a fatal accident inquiry. But I don't think, if I had thought of it, I wouldn't have thought it was satisfactory to move it back to SFIU.
Thank you. I want to move away from the issue of race and ask you some questions now about the instruction of expert witnesses in this case. I wonder if we can return to your statement, please, and look at paragraph 91. I don't have the question handy, but you were essentially asked a question around the instruction of experts, and you said, in general terms, where expert evidence is required for a sufficiency of evidence in a criminal case, the reporting agency, in this case PERC, will be responsible for finding and instructing expert witnesses. However, given that the expert witnesses will be likely to have a significant role in any future proceedings or FAI, the Procurator Fiscal or even Crown Counsel will commonly want to be involved in the selection and instruction of experts. That was what happened in relation to the death of Mr. Bayo. Now, I wonder if I can take you briefly to a statement prepared by Lord Mulholland, former Lord Advocate, SBPI 00476. And if we can look at paragraphs 114 and 115, please. He was asked similar questions around the instruction of experts, and I just want to tease out whether there's any difference between you or perhaps there isn't. Choice of expert witnesses, the choice of experts and instruction lies with the Crown. The Crown may take advice from a reporting agency such as PERC or the police on the appropriate experts to instruct. In other cases where the Crown is not involved prior to reporting, the reporting agency, including PERC, may identify and instruct appropriate experts without recourse to the Crown. And there's a reference made to the Memorandum of Agreement between the Crown and the PERC that the final decision on the instruction of expert witnesses lies with the Crown. So in your statement you say that in general terms it's a matter that rests with the PERC as the investigating agency. They're responsible for finding and instructing expert witnesses. Lord Mulholland, reflecting on his time as Lord Advocate, says that the choice of experts and instruction lies with the Crown, who may take advice from a reporting agency such as PERC. And I just wonder if there's a slight tension between your position and his. It may not come to much, but if I could invite your comment on that.
I'm not sure if Lord Mulholland's statement is referring to the instruction as a totality or the instruction for court, in which case who you use in court is absolutely a matter for the Crown. In practical terms, I think we approach this, I think I've referred to it somewhere else in my statement as we approached it on a collaborative basis. So as you say, it may come to nothing. That would be a matter for the chair. But I think in practical terms, we looked to the PERC to give us suggestions as to who the experts may be, and to give the initial instruction for them. But we were involved in that process from an early stage. I see there is perhaps a tension between the positions, but I don't think it comes to much, because I don't think any expert was instructed in this case without consideration being given by certainly the Procurator Fiscal between myself and Les Brown, but also I think Lord Mulholland was involved in that discussion as well at all stages, so I don't think there was any practical impact.
Can we return to your statement, please? Yes. You said a moment ago that you referred elsewhere to taking more of a collaborative approach, and I'd like to bring up what I think is the paragraph that you're referring to. Paragraph 92, please. I was involved in discussions about the expert witnesses to be used by the Crown. I was also involved in discussions with colleagues in COPFS, in particular with Les Brown, in relation to possible experts that were identified by PERC. That included discussions about the choice of experts, including consideration of their qualification, experience and independence. And you go on to say you don't recall having direct involvement in preparing letters of instructions or being involved in discussions around the material that was to be provided to the experts. And at paragraph 96, were you looking for something, Mr. McGowan? Would you like me to give
sorry,
you a
I
moment?
was just looking at the question because I think I was posed a question in my original request, and something that the Commissioner had said was put to me about, I think perhaps about the Lord Advocate chose the relevant experts, or that was not my recollection that he had specifically chosen them. I think there was a process of discussion between ourselves and PERC, and then between Mr. Brown and I and the Lord Advocate about who ultimately was instructed, and that's what I was looking for. So I'm not sure the particular passage that you took me to in my question is the bit that says that, but it's probably of no moment, given what I've just said. Or
would you like to look at the question
No,
as well for
no,
completeness?
I say I was looking for the particular passage that I recalled, and it was a different question. That's what I was trying to suggest. So I'm sorry.
No, not at all. If you would like to pause to look for something
No.
in your notes or your statements at any time, please just say. In that case, let's look at paragraph 96. This might have been one of the paragraphs that you were referring to. The choice of witnesses was discussed with the Lord Advocate at the time. I recall that these discussions were collaborative rather than being a case of the Lord Advocate personally directing the names of the specific witnesses to be instructed. He could have so directed had he chosen to, and no doubt he suggested witnesses to consider. But my recollection was that PERC sourced potential experts, and these were discussed in COPFS with the Lord Advocate, and we agreed collectively as COPFS and the Lord Advocate who fitted the bill. Those witnesses were so instructed. Is that perhaps
I think that's perhaps the
paragraph?
passage, yes, thank you.
All right, and does that adequately summarise the approach that was taken in this case, a collaborative one that included the PERC making recommendations and discussions at the highest level within the Crown Office?
Yes, I think I would reflect that for the initial choice of witnesses, yes, that was the case. I think we moved on to a period of time later in 2015 where we took a much more hands-on approach. So the first experts were PERC sourced, and I think as we moved on to instruct further experts, that came directly from us with less discussion with PERC and more discussions with the Lord Advocate. So there were maybe two distinct phases.
Yes, we've certainly heard evidence that the initial group of experts were, suggestions were put forward by the PERC. There was this type of discussion and collaboration that you have described here in paragraph 96, and then letters of instruction, although they were sent to the Crown, I believe, in draft, were ultimately issued by the PERC.
That's correct, yes.
And further down the line, the Crown instructed additional medical experts on cause of death and also an expert in the use of force.
Yes, that's my recollection as well, so thank you.
Okay, so there were two phases, and my focus today really is on the first phase and the selection of the experts on the basis of the short list produced by the PERC, and I have a particular interest in Dr. Karch.
Yes.
I wonder if we can look at paragraph 93. This relates to Dr. Karch, and you say, I recall that Dr. Stephen Karch was instructed. He was identified by PERC as having the relevant experience to assist the investigation. There were no initial concerns about him, and his CV was apparently impressive. We were happy that he was instructed, as he seemed to give us insight into the effects of alpha PVP. Alpha PVP was not common in Europe. Now, you say here that Dr. Karch's CV was apparently impressive. Did you consider his CV?
I must have seen it at the time, yes.
Okay. And would the discussions that you had with the PERC within the Crown Office, perhaps even with the Lord Advocate, include consideration of his qualifications, expertise and independence?
It would have, yes.
And what steps did you take to satisfy yourself as to his qualifications and his expertise and his independence?
I think we relied upon the various directories and the CV to give the first instruction. I think, from my recollection, we subsequently had a meeting with the family and their solicitor, and I think at that point we received additional information from Mr. Anwar in relation to some of that which raised concerns on our part.
Yes, and we'll come to that, but I think those concerns were perhaps raised after the letter of instruction had been issued. So if we can perhaps focus on the period leading up to the issuing of the letter of instruction. So his name was put forward, amongst others, by the PERC. You say you must have seen his CV at the time. You would have looked at his CV and directories. And what steps, if any, did you expect the PERC to take in terms of satisfying themselves as to his qualifications, expertise and independence?
Similar steps to the steps that we took, although perhaps not as detailed, to be fair, but I think similar steps.
Was any guidance given to the PERC as to the need to satisfy themselves as to his qualifications, experience and independence and how they should go about that?
No specific guidance was given, no.
Okay. Kate Frame was asked about this in her evidence, and she was asked whether any research was undertaken by the PERC in relation to possible conflicts or potential bias or impartiality. And she said, I don't recall that being undertaken within PERC. And she was asked, was that something you anticipated the Crown doing? And she said, yes, to my mind, they required to be satisfied and the experts they were instructing. Can I ask for your comment on that?
I think it's fair comment that we would have to be satisfied. I don't think there was anything in the material which was available to us at the time that flagged up specific concerns. I can't recall the extent to which we went beyond, or if we did anything beyond the CV and the directories. Of course, giving those initial instructions never committed us to using them at any future stage, and during the process of engaging with an expert, you would look for further information, you would preconise and there would be consultations, and you would explore whether or not there was any conflicts at that stage if you got to that stage with them.
Did you consider, as a precursor to any of that, making contact with them to explore issues of conflict, bias, impartiality, independence, expertise, and so on and so forth?
No, I didn't personally consider that, no.
So I appreciate that those are matters that might have been flushed out in the fullness of time at consultation, but by that point in time, the Crown would have incurred the expense associated with instructing an expert. It would have taken the time that it takes for the expert to read into the materials and prepare the report. So by the time a consultation was set up, if issues surrounding their independence or impartiality or indeed their qualifications or experience only came to light at that later stage, then there's a waste of money and potentially a waste of time as well. And I just wonder whether there might have been something to have been said for picking up the phone or setting up a call with this expert, whether it was the Crown or the PERC, before he was formally instructed to explore these issues.
There would be something to be said for that. I think part of the reason we didn't do it at the time was that, for the reasons I've outlined, that perhaps saw PERC as being responsible for the identification of the witnesses at that time. But no, we didn't do any of that, and I accept that that's a step that could be taken.
Did you have any expectation as to whether PERC would be taking that step?
I'm not sure that I did. As I said in my statement, the original our original view that was that his CV appeared to be apparently impressive. I can't recall what his CV said or whatever, but as I've said, we didn't initially have a concern.
Okay. He was instructed on the 13th of August of 2015. Would you have seen the letter of instruction at some point?
I can't recall if I saw it.
We can bring it up if we need to, but if I were to read it short, he was being asked to comment on the physiological effects of the drugs that Mr. Bai had taken, the effects of the sprays,
Yes.
the effects of restraint, and the effect of all of the above in combination. Does that chime with your recollection?
Yes, my recollection was that he was a cardiologist with an interest in the pharmacological, toxicological aspects of that. I could be wrong, that's just my recollection.
Can we bring up paragraph 94 of your statement, please? Here you're referred to an entry in your notebook dated the 25th of August. Les Brown. J. McSporran was with Nat Carey. He said the experts are the best we could get. Karch, world renowned. And at paragraph 95, you say, this reflects a conversation with Les Brown. In it, he's advising me that John McSporran, a senior investigator at PERC, had a discussion with Dr. Nat Carey, the forensic pathologist engaged by the family. Les Brown was telling me that John McSporran had told him Dr. Carey was advising that the experts we had engaged were the best we could get and that Dr. Karch was world renowned. My recollection was that the decision had already been taken to instruct Dr. Karch at this stage. The information being passed on to Mr. McSporran was not in any way determinative of Karch's instructions having already been given, but it did give, if we could scroll down please, but it did give us confidence that an eminent pathologist in Dr. Carey spoke highly of a witness we were instructed. So you describe here gaining a sense of confidence as a result of this conversation that you'd instructed the right person.
Yes.
Can we continue to paragraph 97, please? And you referred to, again, one of your notebooks, and the text of the notebook has been copied into the typewritten entry. Biofamily meeting 26/8/15. So this is a meeting the day after the conversation with Les Brown, in which you were told that Nat Carey had said that Dr. Karch was world renowned. So the very next day, biofamily meeting concerns Ray Payne James, that was another expert who I understand had been instructed, and Karch, instructed in defence of police, etc. in USA. Experts in just a few days, PERC had concluded view this was an open and shut case, particularly the use of excited delirium. PERC thought it was open and shut. Dr. Carey's serious concerns, proponents of excited delirium, sit on panel in US who exclude restraint techniques and positional asphyxiation. Carey says not acceptable if Karch, would that be ACC?
Yes.
According to Carey, will try to have us believe that restraint techniques not part of COD, that's cause of death. Deborah Coles, who we've heard is from Inquest, says WHO, that's the World Health Organization, says excited delirium is not an accepted term introduced by Karch to UK. She has similar concerns. Carey and Coles say not independent. And you explain it, paragraph 98. My recollection is that this is a note of comments from the family in relation to the expert witnesses that were to be used. The criticisms were more specific and pointed in relation to Dr. Karch. The criticism of Dr. Payne James were less specific. In consequence of the issues raised, we did further research on the witnesses. I recall material to assist us with this was provided by the family's solicitor, Mr. Anwar. When we looked at Dr. Karch in more detail, it did seem that his research was funded entirely by US military and law enforcement, which gave us cause to consider whether Dr. Karch should be used by us and whether he was independent. So this was just the day after the call in which you'd been told that Dr. Carey had said Karch was world renowned, and it's about 2 weeks after the letter of instruction had been sent out. And now you were being told that far from considering Dr. Karch to be world-renowned, Dr. Carey's opinion was in fact that he had serious concerns about both his views and his independence.
Yes.
Did this cause you to query what you'd been told the previous
Yes, I
day?
mean, it was a surprise given the information that I had only the day before. That on one hand, it appeared that we were being told, and the source of that was said to be Dr. Carey himself, was that he was world renowned, and then we were being told that Dr. Carey said that he not only was he not world renowned, but there was a concern about him, and that and so that it was a surprise and a concern.
Did you investigate how it had come about that you had been told that Dr. Carey said Dr. Karch was world renowned?
I don't think that we went back to Mr. McSporran in relation to that. I certainly didn't. It hadn't been me that had spoken to him. It was Mr. Brown who had that conversation. Where our inquiry about this went, as I've said in my statement, is that we then did further research, and we were assisted in doing further research, which took us into who funded Dr. Karch's research, etc. And that did cause us to think that his independence was very much in doubt.
Mm-hmm. So these were concerns that were brought to your door by the family
Yes.
of Mr. Bayo,
Yes.
and they weren't issues that had come to your attention through PERC or
No.
as a result of your own researches?
No, and they ran contrary to, I think, what we, on the face of it, had been told by
Yes.
PERC.
And you discovered through your researches that Dr. Karch's research was funded entirely by the US military and law enforcement, and this gave you cause to consider whether he should be used by you and whether he was independent.
Yes, there was that element of it, and also what we'd been told about his advocacy for excited delirium, which, as I've noted before, was we were aware of excited delirium being a cause of death that was only ever found in people who were in police custody or the custody of the state, and it being a controversial cause of death, which noted the World Health Organization there, but I think we also knew at the time that the Royal College of Pathologists advised that it was not something which on its own was to be used as a cause of death. I don't think they strictly speaking excluded it at that time, but it was certainly not. It was an area that was not. That wasn't something that we would want to rely upon. There did seem to be a lack of independence there.
So you're aware that it was controversial and that the Royal College had said it shouldn't be given as a cause of death.
In isolation, I think was
on
the
its
guidance
own.
at that time.
The inquiry has the relevant guidance before it, I think. Were you aware of any association between excited delirium or deaths attributed to excited delirium in North America and black men?
I'm not sure if I was aware of that at that time, or if I got a greater understanding of that through the work that Lady Eilish Angelini did on behalf of the authorities in England and Wales, where she explored some of these issues. So I couldn't precisely date when I became aware that race was said to be a factor in some of that. I definitely knew that it was said at that time that no one died of excited delirium unless they were in the custody of the state in some way.
Certainly the what you were told by the family, that Dr. Carey had said that in fact Dr. Karch was a proponent of excited delirium, was a cause of
Yes.
concern to you. Okay. Bear with me just a moment, please. I'm mindful of the time, sir.
We'll stop for lunch and sit at 2 o'clock.